Well, good afternoon, everybody. First, I want to thank you for serving on the jury. It's been somewhat of a long trial. Could have been a much longer trial, but I told you right at the very beginning I wasn't going to waste your time. And I know that you have paid attention to the evidence because I've watched carefully, as you were watching carefully. And I know you remember one or two times when I got up and I did some cross-examination, which was pretty rare in this case. And I asked you to write some things down. I went kind of slow, and I looked over, and you were writing them down, and I want to thank you for that. But let me say this, ladies and gentlemen. There are people who think that I am absolutely crazy for taking this case to trial. They say there is just no possible way that I could get you to focus on the evidence, on the elements of the crimes. I mean, look at this case. Horribly inflammatory facts, the worst imaginable. You have a text message in this case sent by my client. She sent it. She sent it to Logan McQuarrie, Gabriel's dad. And what did it say? I killed him. It's hard to imagine a worse text message than that. I would definitely call that a very inflammatory type of a fact. But it's actually worse than that, isn't it? Because shortly after she sent that text message, there were 2 recorded phone calls, just minutes after that text message, where it actually gets worse, right? She goes through that and gives details, bad details, inflammatory details about what happened. Blue body, suffocated him, put him in a diaper bag, threw him in the dumpster. It's almost excruciating to even think about how bad these facts are in this case. But it's still even worse than that. At the end of the day, we got a missing baby. And we still have a missing baby. We got a dad without his son. We got a dad who's someone I didn't even cross-examine. Logan McQuarrie came up here, sat on the stand, talked about how he misses his son. I don't dispute that at all. I think he does miss his son. He's got a prior felony, but I didn't even ask him about that because it doesn't matter to this case. Has he made some mistakes in his life? Yes. Does it matter to anything in this case? No. It's a horribly bad fact for me. And I've sort of concluded, maybe a long time ago, even before we brought this case to trial, there is just nothing that I could possibly do. There's nothing I could present. There's nothing I could stand up here and say to you today to get you to like my client. It's not going to happen. In fact, some people think that you will convict her of anything. You dislike her that much. And there's not a thing I can do about it. If she had been charged with the John F. Kennedy assassination, you'd convict her. There's nothing I can get you to do to focus on the facts. Just because you don't like her, and you will be ruled by your passions. You will be ruled, guided by, driven by your anger for Elizabeth. No matter how hard I try to get you to focus on the elements of the crimes, you will still ignore them. You will ignore your sworn legal duty to hold the state, to prove its case beyond a reasonable doubt. In short, you're just going to shut off your brain. That's what most defense attorneys think about this case. We go to defense attorney seminars. We always talk about, does your case have any jury appeal? This one doesn't have any jury appeal. It's the worst possible case for jury appeal. It's a big issue for us defense attorneys. Why? Because we know juries are made up of human beings, and human beings have feelings and passions. This is exactly the kind of case that most defense attorneys and probably most prosecutors would say, if you're a defense attorney, this ain't the kind of case to bring to trial. Are they right? I don't know if they're right. I don't think they're right. I hope they're not right. I think you can discharge your duty. And ladies and gentlemen, I'm not the only person who thinks that. I may be the only defense attorney, I don't know. But I am not the only person who thinks that you could still do it. The founders of our country had such confidence in you. How do I know that? They talked about the fundamental right to a jury trial. In fact, way back at the beginning of this case, you heard Judge Kramer talk about that. He's absolutely right when he mentioned that to you. He talked about jury service, how important it is. In fact, it's so important, he said, and he's right about this, that there were states who would not ratify the Constitution unless and until there was a fundamental right to a jury trial in the Constitution. I mean, why is that such an important right? It's not important at all until you're sitting where Elizabeth is sitting. You might not even have thought about it till this point. But it's important. Why is it so important? Well, the reality of the thing is that defense attorneys, prosecutors, judges, we're human beings too. And we do a lot of cases. Our system, in case you haven't noticed, is overloaded with cases here in Arizona and in most states across the nation. We see a lot of cases. And sometimes people sort of get jaded. Why? Because a lot of times when you have a criminal case, the person is guilty of something at least. They may not be guilty with exactly what they're charged of. They may be guilty of something lesser. They may be guilty of some of the things. They're usually guilty of something. And we know that. Also, there are times that we've all seen. Everyone who works in these courts has seen times when our system, as much as I love our system, as much as I think we have the best system in the world, the system gets it wrong sometimes. It happens. We have all, the judges, the prosecutors, the defense attorneys, collectively, we've seen it many times. Sometimes people who are really innocent, they get convicted. Sometimes people who are really guilty, they get acquitted. We've seen that. It does happen. And we have a tendency sometimes, the collective we, to sort of cut corners. We have so many cases. We've seen so much. We get a little jaded. We have a tendency to sort of say, well, yeah, I guess we can sort of shave a little bit off the corner on this one and just sort of process the case through the system. There are some prosecutors, maybe, I'm not saying these prosecutors, who might assume everybody's guilty. Second the case comes in, there's a charge, there's an arrest even, they're probably guilty. And in fairness, I'm sure there are defense attorneys who would stand in front of any jury and argue, no matter what the evidence is, jury should come back with a not guilty. You know, the founders, they didn't trust lawyers to decide cases. They just didn't trust us, probably for these reasons. The founders were smart. As much as we've seen Judge Kramer be as fair and even-handed to both sides throughout this case, founders didn't trust him. They did not trust judges to make decisions about criminal cases. It's a little counterintuitive when you think about it, right? Because, I mean, he's got a black robe on. He's an educated man, been to law school, understands all the elements, he can listen to the facts too, right? No problem. Why don't they just put him in charge of deciding? There's a reason for that. He's part of the system. They didn't trust him. They trust you. You are the only ones they trust when it comes to this kind of a decision. You're disinterested citizens. You work outside the system. You're not here every day. You don't know how this stuff is made. It's kind of like making sausage, right? My guess is if you work in the sausage factory, you probably don't want to eat the sausage. But if you're outside, it's different. And you're outside. You're disinterested. That's what we did at the beginning, right? If you heard something about the Elizabeth Johnson case, you knew something about Baby Gabriel, Tammy Smith, you're not on the jury. Unless you heard just a little bit, and you agreed to sort of put that aside. We want you to be disinterested. We want you to be outside the system. That's why there is this fundamental right a constitutional fundamental right to a jury trial in all cases. You are the final check on government power. You're the last stop. And what's nice about it for me, I can stand here on behalf of my client and skip everyone in the system. Everyone. The police aren't involved right here. The prosecutors aren't involved right here. There's no agency of government involved right here. There's no regulation. There's no judge. It's just me and you, the citizens. This is my time to speak for my client. She has a right to speak for herself if she wanted to. She could represent herself. The common person has a right to come here and speak to other common people outside the system. It's a big responsibility. Why is it such a big responsibility? Because these are big questions. These are big issues. This right here, at the end of the day, this is where the rubber hits the road, right? This is where the rubber hits the road. The government can say, we think you did this, we think you did that, but at the end of the day, they don't get to do things to you till we get to this point right here, and you guys make the decision. And it's a criminal felony case. It's a serious case. It's your job to do something, to force them to prove each element of the case, to be the standard bearer, to be the people who set the standard, to say, hey, before we take a fellow citizen and hang a criminal conviction on them, before we do that, no matter how unpopular, there have to be certain things that are shown by a certain standard without any corners cut. It's your job to keep the bar high, to keep it high before you convict someone of a crime. The founders believed, and they said this many times, that government power unchecked becomes tyrannical. Some may argue that our government has been unchecked and is tyrannical in lots of ways. But the question in this case is the government power in this case as it's exercised to Elizabeth Johnson. Putting all that aside for a moment, we had a deal. You and I had a deal, and I know that you remember. I'm going to do my best to hold you to that deal. What was the deal? You know what the deal was. The deal wasn't ever that I get to stand up here and you guys have agreed to come back with a not guilty. That wasn't the deal. I didn't ask you for that deal. What deal did I ask you for? And I brought my questions from way back at the beginning. Way back when there were three giant groups. There was this group here. There was another big, huge group in all of these seats here. Then there was another big, huge group over here. Every seat in the courtroom was filled. Remember back there? I didn't ask a lot of questions, but I asked a few. What did I ask? Well, first I told you some things. I told you that you're going to hear some facts in this case that are going to cause you to be angry at Elizabeth. I know you remember that. I told you there were going to be some facts in here that would cause you to dislike Elizabeth. You knew that going in. In fact, the judge even gave you an instruction. Remember, because we talked about there was going to be this Baby Gabriel issue. I may have even mentioned there's this 800-pound gorilla in the room. Where's the baby? So the judge gave you a preliminary jury instruction. You're not to speculate about Gabriel's status or whereabouts. You get that instruction again today. You'll have it with you when you take it back. I asked you to raise your hands. Please raise your hand if you're unable or unwilling to decide the case based on evidence rather than emotion. I asked you to raise your hand on that. I know you all remember. Please raise your hand. I think I stood right here in this kind of direction so I could talk to everybody. Please raise your hand if you're unable or unwilling to hold the state to its burden of proof, keeping in mind that you're not going to like Elizabeth Johnson. And then the most important one, the one I care about the most, the only part of the deal I really want to hold you to. Please raise your hand if you're unable or unwilling to clearly focus on each element of each crime. That's what our deal is. That's what your deal is. Focus on each element of each crime. That's all I'm asking you to do. And then I talked a little bit about the instruction that the judge gave you, and I asked you if you would be unable or unwilling to follow that instruction, which is the instruction you got here today about the status or whereabouts of Gabriel. And I asked you to raise your hand if you're not able to put aside emotions associated with a missing child. And then I finally said, anybody here just doesn't want to be on the jury? And you know, some people raise their hands. That's okay. What did I want? I want people who want to be here, people who understand that this case is going to involve emotion. This case involves a missing baby. This case is going to make you angry at Elizabeth Johnson. You're not going to like her. But all that notwithstanding, all I want you to do is your job. Clearly focus on each element of each crime. That's it. Now, it seems simple, ladies and gentlemen. Saying it is simple. I'm sure when I said it way back at the beginning of the case, are you willing to do this? Some of you may not have thought very carefully about your ability to do that. But now as you sit here, having heard all the evidence, I think you might understand it's a little bit more difficult than that. The state knows this. The state's well aware of this. Don't be mistaken that the government knows about this situation. The government laid out its case, right? They start, just like her closing today. They started out with the timeline. They put it up on the big screen. Took you from the beginning of the chronology all the way to the end of the case, to the arrest on the 30th of December 2009. We got those late witnesses in. They came in from Miami Beach. But that's not what the state ended its case on. The state went back then in time, saved for the very last piece of evidence one thing. What was the very last thing they wanted you to hear before they sent you out for 2 weeks to think about it? Remember what it was? It was that recording. It was the single most inflammatory, emotional piece of evidence in the case. It's the one she talked about again today. I suffocated him, took his blue body, put it in a diaper bag, threw him in the trash. Remember, we played that on the overhead. That was the last piece of evidence that you got, out of order. Why was that last? Because the state knows the truth of what I'm telling you. There's emotion in this case, and they want to capitalize on that. All I'm asking you is do your duty as jurors. And let me say this as well. Sometimes the right decision, it ain't the easy decision. Sometimes the right decision is the hard decision, the thing you don't want to do. That could be the case. I think it will be the case. Your deal is actually with the judge as well, because he got you to take an oath to do exactly what I'm asking you to do. The deal is with the founders of our country. That's what they thought you would do. They created this system. They fought for this. This is what they fought for, to put you in those chairs. Not to have the judge, not to have the lawyers decide, not to set up some federal agency or some state agency, some bureaucratic administrative agency and let them decide. They fought really hard to get you here because they thought you're the only ones who can do this. Let me talk about Elizabeth for a second. You didn't hear from her. There were things that she would have liked to have got up here and testified to. There were things that were said during this case that she could have got up on the stand and said, hey, you know, this is not shaded the right way. This is a little bit of an exaggeration. But this case isn't about that. This isn't about that. Obviously, it's an emotional case for her. Obviously, it's a difficult case for her. You heard her cry a couple of times. She cried today. She even left the courtroom on one occasion. What occasion was that? The occasion that the most emotional testimony was coming in. It wasn't a surprise to her that that testimony was coming. She exercised her right to not be here for that. It's a hard case for her. But I can stand here and tell you she takes responsibility. How on earth does she take responsibility? I can prove it to you. I stood up here in opening statement, and I told you some things right from the beginning, right out of the chute. I told you they are going to prove that she violated that parenting order. She's authorized me, as her lawyer, to stand here and tell you she was wrong. She committed a crime. I'm her lawyer. I'm standing here in closing argument with her permission, telling you she committed a crime. She made mistakes. She's young. I don't offer this up as an excuse for her mistakes, but as some way to maybe understand a little bit of what was going on. She's unsophisticated, single mom, under lots of pressure, lots of stress, manipulated by Tammy Smith. I say manipulated by Tammy Smith. Who comes up to a single mom with an infant in an airport and strikes up a conversation about taking the baby? Does that seem a little strange to you? Seems a little strange to me. That's the kind of person we're dealing here with, Tammy Smith. If there's one thing you know about Tammy Smith, she wanted that baby, and she was willing to do virtually anything to get that baby. So should Elizabeth have done things differently? Absolutely. Does she wish she could have a redo on a lot of this stuff? Absolutely. We do not dispute the custodial interference charge. We never have. I told you about that from the very beginning. The evidence is solid against her. The state presented a solid case on the custodial interference charge. The evidence is uncontradicted. It's persuasive. How do I get there? I do what you still need to do, but I'll do it with you. We'll look at the elements of the crime. There was joint legal custody, right? At one point, there was a custody order. That's clear. She was supposed to return Gabriel. We know when and we know exactly the minute she was in violation, right? December 20, 2009 at 8 a.m. She knew she was supposed to return Gabriel to Logan, and she didn't. She blew it. Did she know she had no legal right to violate that order? Was she aware of the order? That's an element of the crime you have to look at here. Yeah. Did they prove that? Yes. How did they prove that? They played you a video of the hearing. You saw Elizabeth Johnson at that hearing with Judge McVeigh. She was there. Judge McVeigh went through the dates. They even sort of negotiated a little bit. What day do you want to have the visitation start? Judge McVeigh then very clearly said, okay, fine. They agreed. But if that's not even enough, there's even more evidence that she knew. On the 18th, she was talking to Logan McQuarrie. It's when she made that statement I'm going to get to. You're not going to see him again. The other thing that Logan said was right after that statement, what did she do? She called the court. Just to make sure, hey, do I really have to bring him back? Sure, the court said, yeah, you do. They proved beyond a reasonable doubt that that order was in place, that Elizabeth knew about it, and that Elizabeth didn't return Gabriel in violation of that order. So I can say, as a defense attorney representing Elizabeth Johnson in her trial for custodial interference, in closing argument, in front of the jury, yes, it's true. The state proved beyond a reasonable doubt the elements of custodial interference, and I fully expect that you will come back when we get to that point where you have returned with your verdicts in hand. You will come back and say, yes, guilty on custodial interference. What else is there to talk about on that point? Incidentally, ladies and gentlemen, that was much of the state's case. That was the vast bulk of the evidence that you heard the state present. Nothing against them. They have to present that evidence. That was most of what they presented in this case. Then we get to the conspiracy charge. This one I would term as shaky at best for the state. Very shaky. Now, why do I say that? I think because there's a real question here in terms of how much they actually conspired. And when I say they, Elizabeth Johnson and Tammy Smith, there's a question about how much they conspired. We know they were conspiring at one point. We know they were not conspiring at a later point. When did that change over is the issue in the conspiracy case. When? I mean, you heard Angela Andrews stand up here in her closing just about an hour and a half ago, and say that at one point in the chronology of event, they were not working together anymore. Now, she wants you to think that that point was after the 18th. I submit to you that's shaky at best. So we all agree that they were working together at one point. We all agree they were not working together at another point. Where the dispute is at what point. And why does that matter? It matters because the indictment says the point that they have to prove, the 18th. That's the question in the conspiracy case. That's the issue on the conspiracy charge. Whether they were on the same page, Tammy Smith and Elizabeth Johnson, and at what time and about what, is the question. The only analysis here is the time period in the indictment from the 18th to the 26th. I'll concede they conspired before the 18th. Why will I concede that? Because I think the evidence is strong on that point. They did lots of things together. It's very clear that prior to the 18th, if you just followed the timeline that the state just presented, they were working together to try to get Gabriel adopted out to Tammy Smith. That's what they both wanted to see happen. Logan didn't want that, but that's what they wanted to see happen. But then what happens on the 18th? On the 18th, we know what happens here. Elizabeth leaves. We also know, we don't really have to guess about this part of it because both Elizabeth and Tammy agree, and they both said that when she left on the 18th, it wasn't part of the plan. I would urge you to go back and look at both the CBS interview, the interview with the news, where they talked about that, and the confrontation call. They're both in agreement that on the 18th, going forward, Elizabeth acted on her own. And isn't that sort of what the evidence suggests, right? After she leaves on the 18th, there becomes this frenzy of all this information going on. What's going on, really? Elizabeth is off doing her thing, and Tammy is trying everything she can do to get her to come back so she can get the baby. That's what's going on. Look at the text messages. Look at the MySpace messages. They're not working together after the 18th. Now, I'll throw some of these out as what I would call red herring issues. Things that the state has thrown out there to try desperately to show that they're working together, but don't really work, to show that they're working together after the 18th. We have the Craig Cherry phone number in Elizabeth Johnson's journal. Okay, that was there. What do we know about it? Do we know anything about what Elizabeth Johnson was thinking? I don't know what happened. Did Elizabeth ever call Craig Cherry? Did Elizabeth ever talk to Craig Cherry? What did they say? What was the conversation? What were they planning? Or did Elizabeth say, no, I'm not doing that? I'll call Craig Cherry. Here's what we want you to do. No, I'm not doing that. Or yes, I am. I don't know. Who knows? When was it written in there? Was it before the 18th? Was it after the 18th? Do we know anything about it other than the fact it was in Elizabeth Johnson's journal? No. They want you to speculate about that. They want you to guess about what was going on there. When it was written, what it was about, we don't know. Also, it's interesting to note that Elizabeth Johnson is upset during this time period. The state just pointed this out. Because Logan's not calling. Elizabeth is upset at Logan. Logan didn't call. Why is she upset? Because Logan didn't call. Why didn't Logan call? Because Tammy, who apparently is not working with Elizabeth, asked Logan, and remember she said, the state said at this point, Logan is still kind of trusting Tammy Smith. Logan is in agreement to do what Tammy Smith wanted him to do, not call Elizabeth. Elizabeth isn't on board with that. Elizabeth doesn't even know about that. Why? Because they're not working together after the 18th. If anybody's working together at this point, it's Logan and Tammy. What are they trying to do? Convince Elizabeth to come back. There's also a text message that the state just presented. On December 22nd, 2009, Tammy Smith to Logan. It says, in essence, I hope Elizabeth does the right thing. Hope she does the right thing. Does that sound like someone who's working with Elizabeth? She doesn't have any control over Elizabeth. Remember, there was this little bit of testimony where Tammy was saying, hey, Logan, just sign the documents, sign the custody documents. Give away your rights and I'll get her back. I asked a question about that. Was there any evidence that Elizabeth was on board to come back? No. Nothing. That's because they weren't working together. There's the Janet Morris issue. Janet Morris phone call. Apparently Janet Morris is some person out there, maybe in Tennessee, who Tammy Smith wanted Elizabeth to talk to, and indeed Elizabeth talked to this person. What was that about? Did we hear any evidence about that? I don't know how that could have gone. Maybe Tammy said, hey, there's this person, they can fix everything, do this, that, or the next thing. Why don't you call? Elizabeth calls, they have a conversation, Elizabeth says, nah, I'm not doing that. No, I'm not convinced. Maybe that person was just trying to convince Elizabeth to do what Tammy wanted to do and wasn't able to. Maybe. Who knows? Does any of this sound like proof beyond a reasonable doubt to you? That's the only question here. We have the GPS. Oh, this is solid evidence that they're working together, right? Solid evidence. There's a GPS, and inside the GPS is some evidence that there was a destination in Tennessee. Did she ever go to Tennessee? Where was she going in Tennessee? Why was she going to Tennessee? Why did she put that in there? When did she put that in there? Do we know anything about that? Does this make any sense to you in terms of working together? That's for you to decide. Then we had the MySpace conversation on December 29, 2009, where Elizabeth Johnson tells Tammy Smith, we're okay. Well, if they were working together, wouldn't Tammy Smith already know that? Why is Tammy sending these messages? Hey, Elizabeth, where are you? Are you okay? Just tell me you're okay. What's going on? Does that sound like they're working together? Or does that sound like they're not working together? I would suggest to you, ladies and gentlemen, that the evidence is fairly strong on this point to the contrary. That they were working together prior to the 18th. Then Elizabeth cleans out her accounts, leaves town, and Tammy freaks out, tries to get her back. What are you doing? Come on back. Hey, I got a lawyer for you. Hey, we'll fix everything. Hey, come on back. Hey, Logan, sign this, I'll get her back. Come on back, come on back, come on back. Then later on we get, well, what are you doing? Are you okay? Is everything all right? We have a whole dialogue about this. None of it suggests they're working together. But there is some evidence. There is some evidence that they were working together. There is some evidence that could support a conspiracy charge. And that's why I'm not standing here pounding on the lectern telling you that this is a slam dunk. It's not anything I mentioned. It's something else. Because remember, for conspiracy, you need more than they're just working together, that they're on the same page. You need an overt act. I noticed Miss Andrews forgot to mention that to you when she was talking about conspiracy. There needs to be an overt act. They need to actually do something. An agreement is not enough. They need to do something. So even if these other things got some agreement, what was done after the 18th, where they were working together? There is one thing that you could find that I'll admit, that they were indeed working together and an overt act. There is some evidence in this case, and here's what it is. There is evidence that Tammy Smith is the one who arranged the couple in San Antonio. If you believe that, beyond a reasonable doubt, that Tammy, just like Elizabeth said in her latest statement in the confrontation call, when Elizabeth said, hey, Tammy, you know you set it up. If you believe that what happened here, let me say it like this. If you believe that the state presented evidence to convince you beyond a reasonable doubt that what happened here is that Tammy Smith arranged for the couple in San Antonio to take Gabriel, that would be an overt act, evidence of them working together. But do we have that? Well, Elizabeth Johnson says, as Angela Andrew points out, Elizabeth Johnson said a lot of things that were inconsistent. She said, in essence, there was no conspiracy in the CBS interview. The one with the news. Nope, wasn't arranged by Tammy Smith. But if you listen to that carefully, and I'm not making the case here for conspiracy, I'm just laying out the evidence for you. If you listen to that carefully, it sure sounds like Tammy Smith is leading Elizabeth Johnson around. Hey, Tammy, I didn't have anything to do with that couple in Texas, right? Right? There's no dots that connect anyone to me, right? And there's also no dots that connect to Jack, right? No dots, nobody, we're not connected in any way, right? Elizabeth says, right. I could think of some reasons why the two of them might take that position. But then again, Elizabeth admits in the confrontation call later, the call from jail. She says, hey, Tammy Smith, you arranged this couple in the park. Tammy Smith says, no, I didn't. Yes, you did, Tammy. Yes, you did. No, I didn't. They go back and forth, sort of bickering, if you will, about whether or not it was arranged. Tammy flatly denies it in the confrontation call. So who do you believe? If you listen to Ms. Andrews, and frankly, she makes a pretty convincing case that Elizabeth Johnson made a lot of false statements in this case. No doubt about that. She did make false statements in this case. The question is, can you believe Elizabeth Johnson in that confrontation call beyond a reasonable doubt? I don't think you can. And if you don't, there really isn't evidence that Elizabeth Johnson and Tammy Smith are working together after the 18th in a way where they take an overt act to make something happen. And I'll point out this, ladies and gentlemen, the conspiracy charge, that is the only charge in this case that has anything to do with the truthfulness of Elizabeth Johnson's statements. That is the only charge in this case that has anything to do with the truthfulness of Elizabeth Johnson's statements. There is no other part of the case that turns on the question whether or not Elizabeth Johnson was telling the truth. The state wants you to believe she's a liar. She did lie. They pointed it out better than I could point it out in their closing. I will leave the conspiracy to your review of the evidence. Now, despite me standing here and taking responsibility on behalf of Elizabeth Johnson and telling you that, yes, she's guilty of the custodial interference case, I understand if you still don't like her. That's not enough. It might be nice, though. You might sit there and say, oh, that's nice that Elizabeth is taking responsibility for the custodial interference case. She doesn't have to do that. But I know that's not enough for you to like her. I get it. But fortunately for me, this is not a case about whether or not you like Elizabeth Johnson. In fact, it doesn't even have anything to do with this case. This is a criminal case. It deals with burdens of proof. It's about evidence. You already heard an instruction that you're not to guess about things. This isn't a case where your job isn't to speculate about things. She's prepared to take her lumps on the custodial interference. If you find that she committed the conspiracy, fine. She's prepared to take her lumps. She earned them. Why am I standing here? Because I want to talk to you about kidnapping. That's what this case is really about. This case, ladies and gentlemen, is a horribly, horribly, ugly custodial interference case. There's no doubt about that. It may be the ugliest custodial interference case in the history of the planet Earth. But it's not kidnapping. No matter how hard the state tries, it's just not kidnapping. And I'm going to explain that to you. And in fact, I'm going to explain it to you in a way that if you do the one thing I want you to do, which is just focus on the elements of the crime, I'm here to tell you, and I know this is a bold statement, this isn't even close to a kidnapping case. This is not even a close call. I know that's a bold statement. I'm going to have to prove it to you. Kidnapping is overreaching in this case. It's an attempt by the state to try to capitalize on your outrage, in your anger. It comes under the "she killed John F. Kennedy" clause. That's what it's about. It's like taking a square peg and trying to pound it into that circle hole. No matter how hard they pound, it still doesn't fit. And it's not going to fit. Just as an initial matter, before I even get into the elements, is this really what we think about when we think about kidnapping? I mean, I wonder if this is the kind of thing that most people think about when they say kidnapping. I don't. I realize we have elements to get into. But those of you who may be Tom Petty fans know that Tom Petty did a song about this. Maybe you were kidnapped, tied up, taken away, and held for ransom. Those are not the elements in this case. But that's what we think about when we're thinking about a kidnapping case. What happened in this case? As I've said from the beginning, day one, we all agree on what happened here. We agree on all the pertinent facts. That's why there was very little cross-examination. Elizabeth Johnson took Gabriel. She failed to return him to Logan McQuarrie. She wanted to hurt Logan. She said that. She was mad at Logan. She said some things, no doubt, horrible things. Maybe to put him in grief. Maybe to make him forget about trying to get Gabriel back. I don't know why. Maybe they were just for no other reason other than to get back at him. But that's why we have custodial interference. Kidnapping is a totally different situation. I'll say this as well. You heard Detective Ramirez testify. I had a little bit of cross for her, but not much. And it wasn't really cross, was it? It was a true or false. Tempe did a fantastic job in this case. I have no criticism, no critique, no complaints about the job that the Tempe Police Department did. As a citizen who lives in this community, I'm happy to see that Tempe did a good job. But not only Tempe, they called the FBI. The FBI grabbed the ball, took the ball, ran with it, did a good job. Got with Miami Beach. Miami Beach did a good job. This isn't a case about a bad investigation. No complaints there. No cross-examination from me on any of that. In fact, we don't even dispute anything the state presented. I didn't even put up one witness. I know you noticed. You came in here today waiting for me to call my first witness, and I said the defense rests. I didn't call one witness. I barely cross-examined anybody. Why? Because what they did, what they presented, is not even close to a kidnapping. Now, what they presented, it does matter if what we were doing here is a popularity contest. Then I would have presented witnesses to make Elizabeth look a little bit better. If it was a question about if you like her, I could have presented witnesses. I could have called all her friends. Everybody has friends from a long time ago. I could have brought them in and put them on the stand, and they would have said all kinds of nice things about Elizabeth. I could have done that. Why didn't I do that? Because I don't want you to focus on that question. That isn't the question. If you focus on that question, I lose. We're under the John F. Kennedy assassination clause. I'm dead. That's not the question. My job is to focus you away from that. And towards what? Towards the elements. The things that the state didn't even talk about in their closing. I don't know if you noticed or not. Didn't even talk about that in their closing. Yes, there was a volatile relationship with Logan. Yes, there were fights about Gabriel. Who cares? Elizabeth wanted to give Gabriel for adoption. Logan didn't. Doesn't matter to kidnapping. Elizabeth wanted Tammy Smith to adopt Gabriel. Tammy Smith wanted Gabriel. Tammy Smith forged a document. All that's true. All that I told you in opening statement. My cross, or my true or false quiz with Detective Ramirez that I asked you to write down the points. I could buzz through them real fast. On the 18th, Elizabeth withdraws money from bank account, just like they presented. We agreed. On the 18th, she left with Gabriel. On the 18th, she had legal custody, not violating any order. Kind of an important point. Not violating any order. She had every right to do what she did. 20th, 8 a.m. Court says she's supposed to deliver. Absolutely, yes, she was. Didn't dispute that. Goes to custodial interference. She's in Texas at the time. Then there were the pictures from the 20th to the 26th. Exhibit 120. I asked Detective Ramirez about that. Remember? I asked her about those pictures. She fought me a little bit because I think I gave her too much to chew on. Did he look happy, healthy? Did it all look normal? She, well, I don't, she wanted to fight me on some. But at the end of the day, she finally testified to what we all know. And don't take my word for it. Look at Exhibit 120. Gabriel looked fine on every one of those days. Did he look like a kidnapping victim? Is that what we expect the kind of restraint in a kidnapping case to look like? I would suggest probably not. 26th, last picture of Gabriel. 26th, no evidence of Gabriel's whereabouts after the 26th. And then I got her to agree. We fought a little bit about this one. No physical evidence to confirm or deny Elizabeth Johnson's conflicting statements. What am I saying there? We don't know. We don't have any evidence, not a scrap, in terms of what happened really with Gabriel. The only evidence in the entire case that she actually killed Gabriel were the dumb statements that she made, that she took back on the same day, by the way, when she talked to Tammy Smith, that she took back again when she spoke to the police. But it doesn't matter to this case. What is something that's important here? When did I get my butt off my chair and stand right here and put some evidence, some questions together? 12:27, 10:15, Tornado bus station. Remember, we had Mr. Chavez, I think it was. He came in. He was pretty clear. He remembers Elizabeth Johnson. He remembers her. He said she was pretty. He remembered looking at her. He was very clear. In fact, the timeline is now the state's timeline. They put it up this morning. We all agree. What do we agree happened on the 27th? 10:15 in the morning, she's there by herself. By herself. By herself. Not with Gabriel. Not with Gabriel. 11:53. I killed him text sent to Logan. No Gabriel. Or said another way, no restraint. She didn't even have Gabriel at the time she made that statement. Oops. You might have thought that the state would have tried to address that in their closing argument. I think they may be painfully aware of this problem. At the time of the I killed him statement, and at the time of that entire phone call, immediately preceding, there is absolutely no question whatsoever at all. She didn't even have Gabriel. Didn't even have him. Where he was, not sure. Where he was not, 100% sure. Not with Elizabeth. Then she gets on a bus, no Gabriel. She talks to Lenzen. There was some evidence that whether or not she had Gabriel at the time, but it's clear at this point, and Detective Ramirez admitted she didn't have Gabriel at that point. The bus is then moving. Remember, we went through all the cell towers and the phone calls. Everybody agrees on the evidence. She's heading for Miami Beach, no Gabriel. She gets off, she checks into the hostel, no Gabriel. Rested in Florida, 12:30, no Gabriel. So, what's irrelevant to kidnapping? Let's talk about what doesn't matter. Was Elizabeth Johnson really a good mom? Does that matter to the kidnapping charge? No. Not relevant. Was she a good girlfriend to Logan McQuarrie? No. Did she say mean things? Doesn't matter. Do you like her? Is she a liar? Is she a liar? Doesn't matter to the kidnapping case. Which version of events actually is true? The diaper bag, blue baby, dumpster version, or one of the, I would say, maybe subversions? The state wants you to believe that they're very different. They're really not all that different. She gave the baby to a couple that she met in San Antonio, Texas. Maybe she met them in the park and gave them in the hotel room. I don't know. But that version, which of those two versions is the truth? Does not matter to this case. Where is Gabriel? What is his status today? Doesn't matter. The state is really hoping that you will focus on these irrelevancies. How do I know that? That was most of their case. Remember at the beginning, we had what seemed like endless witnesses from the 99-cent store where Logan worked. They all came in. I don't know how many different witnesses came up here to say, yes, Elizabeth was mad. Elizabeth came in. She created a scene. She followed him to the back. The employees were mad. The boss was mad. Everybody was mad. It was a disturbance. The police were called. She lied. What does that have to do with kidnapping? What does that have to do with anything? Nothing. My sole job here is to get you to do your job. And if you focus on the elements that I'm getting ready to go through right now, you're going to see this is, as to kidnapping, slam dunk. Don't be swept away and blinded. That's it. If I can get you to not be swept away and blinded, you will come back with a not guilty on kidnapping. Of course, you have a duty not to get swept away and blinded. You're obligated to look at the elements. What I'm asking you to do is what you've agreed to do. I'm going to give you 3 separate, independent, totally stand on their own reasons why this isn't kidnapping. I'm going to ask you again to write them down as I take a quick drink. And I'm going to tell you this up front too, because however this case turns out, I want you to say that Mark Victor, when he came in from opening statement to closing argument to jury selection, I didn't mislead you on anything. Not a scrap of anything anywhere. I want to have 100% total integrity with everything that I've said to you from the beginning to the end. And so I'm going to tell you this. The first 2 reasons, slam dunk. Either of those 2 reasons, slam dunk. And I got to tell you, I wrestled with whether or not I even want to talk about the 3rd reason, because frankly, I don't think I need to. I could stop after the 1st reason. But the 2nd reason is such a slam dunk, I couldn't stop after that. The 3rd one's a little weaker. And again, conventional wisdom, maybe you don't talk about the one that's a little bit weaker, a little bit more complex, because it could detract from the 2 slam dunks. So I presented to you with that in mind. But the 3rd one is a legitimate reason that does, if all I had was that, I believe you would still come back with a not guilty, because it does create reasonable doubts. I think the state would like you to believe that the elements of kidnapping are slightly different than the elements given to you by the judge. What the state would like you to believe is that the elements of kidnapping go like this. If you believe Elizabeth Johnson is a liar, she's guilty of kidnapping. I wish I had one of those clocks that they have in the debates, the presidential debates and the vice presidential debates, that I could run. How much time did the state spend on convincing you Elizabeth Johnson is a liar? And how much time did the state spend trying to go through the elements of the kidnapping charge? That would be interesting. Here's what kidnapping is. You have them in your jury instructions. Knowingly restraining another person with the intent to place Logan McQuarrie in reasonable apprehension of imminent, not past, but imminent physical injury to Gabriel Johnson. It's not any kind of physical injury. It's an imminent physical injury, one that is about to happen in the future. as if you need a definition of imminent. It's in your jury instructions just in case. Imminent is not about the past. Imminent is about the future. Then there is a definition of restrain, what it means to restrain somebody. And I'm going to get back to that. But there's a definition of restrain. And I'll tell you what the definition is not. The definition is not if you're in violation of a custody order, you're restraining. That's not the definition. The definition is not if you take your kid and you go to Texas and you don't return your kid, that's restraint. That's not the definition. The judge gave you the definition. It's a very detailed, very clear definition. And all of this has to happen between December 18, 2009 and December 30, 2009. Why those dates? Because December 18, 2009 is the date Elizabeth Johnson left Arizona, and December 30th, 2009 is the date she was arrested. Now, let me point this out, because this is one of the parts of this case that has worried me from the very beginning. Logan McQuarrie's state of mind is not an element. You have a jury instruction that says that. Why am I worried about that? I don't want you to be confused about what was going on, or even think about what was going on in Logan McQuarrie's head, because it doesn't matter to the kidnapping charge. It's not an element. The kidnapping charge is about what was going on in Elizabeth Johnson's head. That's why that jury instruction is there. So you don't think, oh, Logan McQuarrie, maybe he was in fear of an imminent physical injury. That's not kidnapping. Kidnapping was Elizabeth Johnson intending to put him in fear of an imminent physical injury. Does not matter what Logan believed. It really doesn't even matter if Logan ever heard the "I killed him" statement. Elizabeth Johnson, her intent is the focus. In fact, just to give a sort of more extreme illustration of this, I could imagine a situation where the state presents evidence that Elizabeth Johnson writes a letter to Logan McQuarrie and writes in the letter, "Hey Logan, I just want to let you know I'm getting ready to cause a physical injury to our kid Gabriel." Seals it up, puts it in the post office box. And the postal carrier, as they sometimes do, lose the letter. And it never makes it to Logan McQuarrie. He never reads it, doesn't know anything about it, and his testimony is nothing more ever than, "I always thought Elizabeth was a wonderful mom to my kid Gabriel." They could convict her if they could show restraint happening at the time she had that intent. I hope everybody understands that it doesn't matter what's going on in Logan McQuarrie's head. So imminent. You have a jury instruction. It's a little bit convoluted. I know that most of you, maybe hopefully all of you, know about the word imminent. But there's a jury instruction on the point of happening or threatening to happen at once. One thing we know imminent is not is something that happened in the past. Something that happened in the past is not imminent, period. Okay, let's get to my 3 reasons. I'm going to ask you to write them down. Number 1, Elizabeth Johnson's intent is entirely focused on past injury, not imminent injury. Period. All of the statements in this case, if you took all of the statements that are presented in this case, that are made by Elizabeth Johnson at any time, that have any connection to any kind of a threat of physical injury, they all occurred on one day, which is the 27th. And there's a lot of them. What is it that starts the ball rolling? Well, I killed him. Pretty clear, pretty unambiguous. That's the text sent on the 27th. I killed him. Now, if the text was different, if the text said, I am gonna kill him, I'm not standing here talking to you about this. If it said, I'm gonna kill him maybe in 6 months, kind of a weird statement, I might be standing here saying, hey, there's a threat of physical injury, but it's not imminent. But a statement that says, I killed him, there is no construction of anything I'm aware of in the English language that would allow you to take that statement and accept that as evidence of Elizabeth Johnson's intent to put Logan McQuarrie in fear of an imminent physical injury. But it doesn't stop there. There's the recorded phone call. Now you've got this. It's Exhibit 13. Miss Andrews went through it all. I'll go through some selected passages. There are statements in this recorded phone call between Elizabeth Johnson and Logan McQuarrie that occurs on the 27th of December 2009, minutes after the I killed him text. Maybe there's something in here that is evidence of her intent to cause an imminent physical injury. Right? Let's look at it. Lots of statements in here. Some of them are about Logan, and they're in evidence, and so you can see them. On page 1, and you have this, by the way, so you can look at it. But please, don't take my word for it. Look at it yourself. Why would you send me a text message like that? Because I know you're lying. You can't send me a text message saying you killed my son. And then Elizabeth on page 2. You made me kill my baby. Made me kill. Past tense. Unarguably, unambiguously past tense. Elizabeth, you're not going to hurt Gabriel. You love him too. You would not hurt Gabriel. You know you wouldn't. Elizabeth, Gabriel's in the dumpster. Does that sound like it's an imminent physical injury or something that occurred in the past? Logan says, no, he's not. Just in case you're not clear, Elizabeth says, I told you that I killed him this morning. Already done. And then again, I killed him this morning. Logan, no, you didn't. Page 5. You know where I am at, Logan. You don't care about me. All you care about is Gabriel. That's the statement that she read to you. But what comes next? And he's gone now. You made me do something that's going to kill me now. Why did you do this? And then again, on page 5. It's already been done, Logan. And then again, page 5. You made me kill my baby boy. Next page, page 6. Logan says, you did not hurt Gabriel. Elizabeth says, yes, I did. I suffocated him. I covered him up with a towel. I suffocated him. He turned blue. I put him in his diaper bag, put him in a trash can. All passed. And then on the last page is what I would call the grand finale in terms of evidence of Elizabeth Johnson's intent that is contained on the 27th of December. It's the second to last line. Just look at it. It's already done, Logan. It's already over with. It's done. And there, ladies and gentlemen, you have now heard the sum total of all of the statements that have been presented to you as jurors in State versus Elizabeth Johnson that relate in any way to any physical injury. You are now asked to decide, based on that evidence, can you conclude beyond a reasonable doubt that Elizabeth Johnson had an intent to put Logan McQuarrie in apprehension of an imminent physical injury? I would call that a slam dunk. Now, ladies and gentlemen, lest you think this is a technicality, it is not. It is an element of the crime. It is one of the elements of the crime that the state must prove to you beyond a reasonable doubt in order for you to come back with a kidnapping. That's it. What was really going on here? Elizabeth Johnson was trying to place Logan McQuarrie, I would say, in grief. Not fear of an upcoming, imminent, soon-to-happen physical injury, but it's a past injury only. Now, was this something that you think might have been done in anticipation of this case? Do you think maybe Elizabeth, when she was out there on the 27th, on the run, unsophisticated, Elizabeth Johnson, acquainted with the elements of kidnapping, thought maybe she would shade her statement so it wouldn't fit with the kidnapping statute? I don't think that makes sense, ladies and gentlemen. And even if it did, that's all we've got. She has no idea that she's even being recorded at this time. She doesn't even know that Logan is recording her. She's completely unaware. I would say this is great, very good evidence of what's genuinely going on in her head. It's just, another way to say it, it's just the truth about her mental state. There is no other evidence anywhere in this case about Elizabeth Johnson's state of mind that has any connection to a physical injury to Gabriel. But that 12/27/09 call, Angela Andrews talked about that call. I got to tell you, you couldn't see what was going on inside of me when she was up here, standing right here, going through that call. She read through it just like I read through it. I was sitting there, maybe you were looking at me, but if you had a blood pressure monitor on me, I can tell you it was going up. Why? Because I couldn't believe what she said. And maybe it snuck right by you. I hope it didn't. I hope you wrote it down. In fact, if I get it wrong, maybe Ms. Raimundo, when she comes up here for their second bite at the apple, can fix it. Because I'd sure love to hear it. What did she say about that? She very casually said, this should be interpreted by you as, I could very well hurt Gabriel. That's what she says those statements mean. I could very well hurt Gabriel. Why does she say that and just brush right over it? Because she knows there's a problem. Without that giant leap, without that, you got to come back not guilty on kidnapping, and she knows that. That's why she tried to take that, maybe hoping that I wouldn't say anything about it, I don't know. Maybe hoping that you would write that down, take it back in the jury room and not look. I don't know. But that's going to be necessary. One of the things that's necessary for you to come back with a guilty on kidnapping. You got to believe that the construction of I killed him and then all the statements, he's gone, he's dead, it's done. What that really is in evidence of Elizabeth saying to Logan, I could very well hurt Gabriel. That's them just sort of glossing over the facts. So what is required to believe? That when Elizabeth Johnson was saying this, she really wanted to put Logan in fear of an upcoming physical injury, an imminent physical injury. That's what she was really trying to do, even though she said all that stuff about past stuff. She was hoping that it would be sort of construed differently or something. That's what you have to believe to make this work. I don't know. Seems to me, if Elizabeth Johnson wanted Logan to McQuarrie, if it really was her intent to put him in fear of an imminent physical injury, maybe she would have said, I'm going to kill him. Maybe she would have said, I'm about ready to do something, or I'm thinking of hurting him, or any of those statements would have been fine. But that's not what she said. That's not what the evidence is. That's the leap that the state wants you to make. You got to deal with that. Is that your job as jurors here, to just write that in? The statements are the statements, ladies and gentlemen. I could very well hurt Gabriel. How do you get that out of what I just read? You don't. But then there were some other things that kind of slid right by that caused my blood pressure to go up a little bit. There was the 12/26/09 statement. You remember that statement? Recorded telephone call, December 26/09. There was a statement in there. You have the recording. You have the transcript. Exhibit 14. She talked about only one thing that was in that. I'm allowed to move. Remember, she made a big deal out of that. 12/26/09, I'm allowed to move. She said, yeah, she's allowed to move, blah, 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 blah. But she never mentioned the first part of that statement, which was, you will never see him again because I'm allowed to move, because I'm allowed to get a job. She didn't mention, you're never going to see him again. Why did she not mention, you're never going to see him again? Why? I know exactly why. Because that statement, Logan, you're never going to see him again because I'm allowed to move, is talking about a custody battle. Again, look at the statement. All through the statement, she's complaining Logan doesn't care about Gabriel. Here's what she says. I'm doing more for him than you'll ever do. Pay child support. You don't want to do that. And why does she need that? Because there's a statement out there on December 18th. That's exactly the same statement. She's going to want you to use that statement. Remember his testimony? December 18, you're never going to see him again. She's going to take that statement and try to springboard that into, even though it doesn't have a physical injury, that is her intent to put Logan in fear of an imminent physical injury. But if you understand that she made exactly the same statement on the 26th, you will never see him again because I'm allowed to move. I'm allowed to get a job. Then it makes sense. She would rather have it just dangling there and not illustrate for you that on the 26th, that statement is connected in the same sentence to a custody discussion. I mean, that's really what's going on here. There's no threat of physical injury. The December 18th statement she threw out there, you're never going to see him again, but she forgot to mention something there too that Logan testified to, like I said earlier. She then went and called the family court to find out what the rule really was. Why? What is she doing here? She's trying to keep Gabriel from Logan. We know that. She's guilty of that. That's why it's a custody interference case. Now, ladies and gentlemen, there is something else. And I'm glad I didn't have a stroke over there because my blood pressure was going up. You got a lot of MySpace messages in the state's closing argument. She went through, put lots of stuff up on the big screen. All kinds of stuff. But she forgot something. She forgot to put something up there for you. Fortunately, we didn't forget to get it into evidence, so you have it in your hands to look at. And I would urge you to look at it. The MySpace conversation. One on 12/15 of 09, one on 12/16 of 09. Just a couple of days preceding the December 18 statement. Why didn't she even mention those? Skimmed right over them. Why did she do that? It connects to the same reason why. And let me just preface this by saying this statement. Logan McQuarrie's state of mind does not matter to any element in this case. But does it make sense why Logan didn't believe the statement that Elizabeth said I killed him? Why? Because there's an avalanche of evidence that she loved Gabriel and was doing everything possible to care for him. Every single scrap of evidence in this case about Elizabeth Johnson's mental state in regards to Gabriel Johnson is that she loved him and was caring for him right up until the 27th. Don't take my word for it. What does she say in the 12/15 MySpace conversation? What does Elizabeth say to Logan? What does she want Logan to believe about her relationship with Gabriel? Here's what she said. I want what's best for Gabriel. Gabriel doesn't deserve to be in the middle of a custody battle. This is my favorite one. If you want to know what Elizabeth Johnson wants Logan McQuarrie to believe in relation to Gabriel, here's the one I like. You know I love and adore Gabriel. I would never hurt him. I would never hurt him. Gabriel is my angel. You left me no choice but to consider adoption. We can't provide for Gabriel. Gabriel deserves a real family that is stable and emotionally healthy. The adoptive family is willing to do an open adoption so we can still see him. I have always done the best for Gabriel, and I always will, even if it means giving him up. I don't wish you anything bad. I forgive you. 12:15. Does that tell you anything about what's going on in Elizabeth Johnson's head? I suggest it does. Why would the state skip right over that? But then there's December 16, the very next day. MySpace conversation. You have it in evidence. Look at it. Elizabeth Johnson to Logan McQuarrie. I can't take care of him right now. You don't support us or help out in any way. You leave and abandon us and don't contribute. You never have. I pay for everything myself. You may see Gabriel whenever you wish. All you have to do is call, which you have not done. Gabriel is in my custody. Here comes the best part of this one, or one of the best parts. I am taking care of him and will continue to. You have no right to take my son away from me when I've cared for him by myself financially. I've made sure Gabriel has everything he needs. I've taken Gabriel and myself to all our doctor appointments. I have a couple letters of recommendation from professionals accounting for my good mothering. I have a certificate from the pregnancy center I attended. I'm not mad at you. I'm not doing this to get back at you. I am taking care of my son. You cannot take my baby from me. I have been a great mother. I have done everything for him. That is what Elizabeth Johnson said to Logan McQuarrie. I would say, whether it's true or not is not relevant. Whether it's true or not doesn't matter. That's what was in Elizabeth Johnson's head that she communicated to Logan McQuarrie. That's probably why Logan McQuarrie was such in shock when he heard on the 27th. He knew there was a custody battle. He knew she wanted to adopt Gabriel. He knew she was trying to make this happen. At some point he figured it out. Why did she make that happen? She said it as clear as day. Logan wasn't helping. I'm sure he's not a bad guy, but he wasn't helping as much as she thought he should help. And so she thought Gabriel was better off with another family. She thought Tammy Smith was a good family, a good place for him to go. That's what she was trying to get done. There's an avalanche of evidence to the contrary in this case that starts on 15 and 16 and does not change until the 27th. The first day there's even a thought about a physical injury to Gabriel, and it's 100% unambiguously in the past. There is simply no evidence anywhere in this case, none, that Elizabeth Johnson intended to place Logan McQuarrie in fear of imminent physical injury to Gabriel. Not only is there not any evidence of that, there is lots of evidence to the contrary that she was trying to convince Logan that she was a good mom. Evidence of a past injury isn't going to get us there, no matter what the state wants to say about it. It doesn't get them there, and it can't get you there beyond a reasonable doubt, and you're not to speculate or guess. So we can look at the universe of statements that we have, given the time period that we have in the state's indictment. We got the 1215 MySpace that I just went over, the 1216 MySpace, the 1218, you're never going to see him again, which is accompanied by the call to the family law court, that we didn't get all the other evidence. They could have asked other questions. We didn't get any other evidence on that. The 1226, you're never going to see him again because I'm allowed to move and get a job and do all these things. Then we get the 1227, I killed him text in the past, and the 1227, I killed him with details phone call. That's what we got. Maybe Miss Raimundo will get up here when I sit down and say, no. Mark Victor has it completely wrong. There's other statements out there upon which you could find beyond a reasonable doubt the mental state in this case. I'd love to hear them. And you're not going to, because there are none. Now, of course Elizabeth Johnson was wanting to hurt Logan McQuarrie. There's no doubt about that. That's what she said. But wanting to hurt him isn't enough. You got to want to put him in fear of an imminent physical injury. That's what the statute says. It's how she wanted to hurt him. That's what's required by the kidnapping statute. And the only how that applies is you have to want to hurt him by making him fearful of an imminent physical injury. That's all it is. It's no other kind of hurt. I'm not excusing the conduct. I'm not saying it was okay. I'm not saying you should like her. I'm saying clearly focus on the elements of the crime. The state's trying to convince you that Logan said Gabriel is dead because her real intent was to convince him that he should be in fear of an imminent physical injury. I can't even say it with a straight face. It doesn't make sense. Based on everything I just said, you have to come back not guilty on kidnapping because they haven't proven the mental state. They just simply didn't present even evidence to you of the mental state. Now, I could stop right there.
And Mr. Victor, let me stop you right there since we're at a time for a break before you transition into another area. Now's probably a good time to do it. So we're going to take about a 15-minute break since it's the mid-afternoon. We'll be back at about 3:15. Until then, remember the admonition. We'll pick back up with the defense closing argument then. We'll see you in about 15.
So, ladies and gentlemen, what I was saying at the time was, I think I could just sit down at this point. And I was sort of thinking about it, but we got a break. So I guess I'll continue on. Problem number one is what I'll refer to as the imminency problem, because the state doesn't have the evidence to prove that there ever was an intent to put Logan McQuarrie in fear of an imminent physical injury. The only last thing I want to say before I move to number two is just to remind you, because Ms. Raimundo may get up here and start talking about Logan McQuarrie's state of mind again. I hope she doesn't. I hope that you don't focus on that. You have a jury instruction. It really doesn't matter what Logan McQuarrie believed about this. The focus is on Elizabeth Johnson's state of mind. So I think I could stop right there. I think I have presented enough now where it's absolutely clear there is no way the state proved the elements of kidnapping because of the imminency problem. But there's this other really huge, just as significant problem as the imminency problem in this case. What I told you was the first two reasons, in my view, are slam dunk reasons. They're both huge gaping holes in the state's case. So let me talk about that. Reason number two, I'm going to ask that you write it down. I call this reason the concurrency problem. And what I mean by that is the statute says for kidnapping, and again, I'm just talking about kidnapping here, two things need to happen at the same time in order for Elizabeth Johnson to be guilty of kidnapping. The state needs to prove to you that not only that these two things happened, but that they happened at the same time. Number one, there has to be restraint. And number two, they have to have the relevant state of mind, which is the intent to put Logan McQuarrie in fear of an imminent physical injury. What does that mean? If the state proves that there's restraint, but at the time there's restraint, the relevant state of mind is there, not guilty. If they prove the relevant state of mind, which I've just shown you they're not even close to proving, even if they do prove it, if there's no restraint at that time, there's no kidnapping. The state has to prove them both at the same time beyond a reasonable doubt. So, even if we took the "I killed him" statement and changed it, as Miss Andrews would love you to do, change it into the "I am going to kill him" statement, okay? The imminency argument's dead at that point. I am going to kill him, or I'm going to cause a physical injury to him. Let's say that problem is completely fixed. The other problem with that? She didn't have him on the 27th. He was gone. Wherever he was not being restrained by Elizabeth Johnson. And they need to prove that those two things occurred at the same time. Whatever Elizabeth Johnson did with Gabriel Johnson, and we don't know, and you don't have to figure it out, whatever she did, she had done it prior to the 27th. And we all know this is true because we all agree on the timeline. Elizabeth Johnson is alone at the bus station. That's where she made her statements. We heard Mr. Chavez testify. But just to be sure, we can go through the timeline of 12/27 of 09. And this is the timeline that we all agree on. 11:47, Elizabeth Johnson receives a call from Tammy Smith. She's at the Tornado bus station. You have this in evidence. How do we know that? She's either at or around the Tornado bus station because there's a cell tower there, and it's conceivable she could be around the station. But we know where she is because we heard Chavez say she was sitting on a bench. He was watching her. She was alone. The "I killed him" text message doesn't come until 12:53 p.m. Undisputed. If that statement, instead of "I killed him," is "I'm gonna kill him," it still doesn't matter because she's not restraining Gabriel at that time. 12:56, that's when we get the recorded phone calls, 3 minutes later after the text message, and all of the discussion in that phone call. But if you change it all from "I killed him" to "I'm gonna kill him," no, you're not. Yes, I am. I'm really gonna do it. I'm gonna kill him. I'm gonna kill him. Still doesn't matter because she's alone. She's not restraining Gabriel Johnson at the time. And then from 108 to 121, there's several phone calls. We know what's going on. She's traveling north on I-38 away from the bus station onto Miami. 252, she gets the call from Detective Lenzen. We know she's traveling on I-10 on the bus to Miami. No Gabriel. State knows about this problem. They just brushed it over. They just flat ignored it. She's just simply not restraining Gabriel Johnson when she makes the statement, whatever the statement is. You had a jury instruction on this point. This isn't just me telling you something. It's in your jury instructions. The judge has already read them to you. He went by rather quickly when it came up. Maybe you weren't paying attention because you didn't know that was important. But fortunately for me, you're going to have those jury instructions to go back there. Don't take my word for it. Look at the jury instructions. What do they say? Here's what it says. The state must prove the requisite intent existed at some point while Gabriel was being restrained. That's what they have to prove. Okay? When is the window of time for restraint? Let's look at that. The earliest possible time there could be restraint in this case is 12/20/09, 8 a.m. That's when the window opens. Why? Because that's the moment at which Elizabeth Johnson was required to give Gabriel Johnson back to Logan. Before that, you heard Detective Ramirez testified, nothing wrong, not violating any order, no problem. We even heard Angela Andrews say today she had every right to leave the state on the 18th, no problem. So when is the first possible opportunity? 12/20/09, 8 a.m., when she's required to return Gabriel. When is the latest possible opportunity for restraint? Sometime on 12/26 of 09. That is the latest time that we have any evidence in this case that Elizabeth Johnson even has Gabriel Johnson. So that's the window. That's where we can look at to see if we got everything we need. So the December 18th statement, let's talk about that for a second. December 18th, you're never going to see him again. We've already talked about that statement a little bit. We know what's going on. It follows on the heels of the 15th and 16th and all that conversation. What's really happening? She's getting ready to take Gabriel away from custody. She's letting him know that's what she's really saying. But what if we change that statement on 12/18 to "I'm going to hurt him"? Doesn't matter. Even if that statement on December 18, 2009 could be the requisite intent, the state of mind that the state has to prove, it's too early. There's no restraint. She's not violating any order. Then we have the statement on 12/26 That's the latest statement we got that could possibly be the requisite state of mind during the time there's restraint, 1226. But I already talked to you about that statement. That's, you're never going to see him again because I'm allowed to move. That's the universe of statements that we have. The 18th is too early, and the 27th is too late. The 18th, she's not restraining. She has her kid, and she can do whatever she wants at that point. The 27th, too late. Everybody agrees she doesn't have Gabriel. There's just simply no restraint. Don't take my word for it on the 26th, by the way. Listen to the call. Listen to what she says after she says, you will never see him again because I'm allowed to move, because I'm allowed to get a job. That's very far from evidence of Elizabeth Johnson trying to put Logan McQuarrie in fear of an imminent physical injury to Gabriel. That's really all you got. That's what it whittles down to, that statement on the 26th. If you take out the 18th, which you have to do, which you don't really have to do because there's no imminency there. It doesn't get us there in any event because of problem 1. Take out the 27th, which you don't really have to do because of problem 1, the imminency problem. All we got left is the 26th. And as I've already said, the 15th and 16th, we have an avalanche of evidence to the contrary. That's the interesting thing about this case with the mental state. Not only, you could take away the 15th and 16th and still say the state hasn't presented evidence to prove the mental state beyond a reasonable doubt. But even without that, we have an avalanche of evidence to the contrary. That's problem number 2, the imminency problem, the concurrency problem. So even if we throw the imminency problem out the window, which frankly, I have no idea how we could possibly do. I'm sure Ms. Raimundo will now have to get up here and address this. I hope she comes up here and stands here or there and says, Mr. Victor said there were 3 problems on kidnapping. Problem number 1 he described as the imminency problem. Here's why the imminency problem is not a problem. She's got to do that. Hopefully she'll do that, and then you'll evaluate whatever it is she says. Then she can move to problem number 2, the concurrency problem. Here's why what Mr. Victor said is not a problem. What is she going to say? Probably, you should just accept that there's restraint even though she doesn't have him. You should just accept that she's still restraining. Even though she doesn't have him, even though we don't know where he is, even though we don't know what's going on, even if he is in a dumpster, she's still restraining. She's restraining a dead person at that point. What else can she say, right? What else could she possibly say other than to come up here and say, it really doesn't even matter, don't worry about it, just ignore it, it doesn't matter that she doesn't have him. She can't say she really has Gabriel on the 27th, because we're stuck with that. Maybe she could say on the 18th, even though they've said in their closing already, there's no violation of anything on the 18th. There's no violation of anything until the 20th at 8 a.m. Maybe she'll say, well, it's still restraint. Okay. You can evaluate that. Reason number 3. I could stop after 1 and 2. Frankly, I wouldn't mind doing that, but there is still reason number 3, and I would be remiss in my duty if I didn't point this out. Not as strong as 1 and 2 as I've said, but still enough even by itself to raise reasonable doubts. Reason number 3 is simple. There isn't any restraint here. There never was. Not restraint for kidnapping. You might say there's restraint here in the sense that any parent sticks their kid in a child restraint seat. Yeah, it's true. Parents restrain their kids. Parents take their kids places. There's some aspect of restraint in everything a parent does with an infant. But is that what we're talking about here in kidnapping? Fortunately, we don't have to bicker about that because you have a definition of what restraint is for kidnapping. As an initial matter, I would say take a look at Exhibit 120. Those are the pictures of Gabriel at the Homegate Hotel. Take a look at him sitting there, smiling like any other kid. Does this look like restraint for kidnapping? I would suggest to you it doesn't fit. The reason it doesn't fit is because it isn't the kind of restraint that we expect to see in a kidnapping case. What will they say? Probably, I don't know, but maybe Ms. Raimuno will come up here and address problem number 3 and say, problem number 3, don't worry about problem number 3 because, she's violating the custody order at that point, and that's enough for restraint. Is it? You have a definition of restraint. Nowhere in that definition does it say, or if a parent is violating the custody order, that's restraint. It doesn't say that. I mean, if I'm wrong about that and you see that in there, then I guess number 3 is not going to work. But it doesn't say that. You got a definition in your jury instructions about what restraint is. And frankly, violating the custody order, that's what custodial interference is about. That's why we have a crime of custodial interference. And that's really what happened here. All we got here at the end of the day, is an ugly custody interference case, custodial interference, with a threat of past harm while not having Gabriel. That's it. That's the only other aspect of this case. That's why kidnapping is overreaching. What does restrain mean? To restrict a person's movements. Does that fit here? Really? When you look at those pictures, is she really restricting a person's movement for restraint under the kidnapping statute? Is it without consent? Without Gabriel's consent? Well, we're going to get a definition of that in a little bit. Without legal authority. I'll give you that. Whatever she did after the 20th at 8 a.m., she was doing it without legal authority. That's what they're going to try to hang their hat on. They're going to say, well, because it's without legal authority, that's enough to get restraint. But it's not. Without legal authority is one thing that is required of many things in the definition of restraint. That's why they're ands and not ors. Restraint means to restrict a person's movement without consent and without legal authority and in a manner which interferes substantially, not just a little bit, but interferes substantially with such person's liberty. Is the parent, Elizabeth Johnson, the parent interfering with Gabriel's liberty substantially by what she was doing at the Home Gate Hotel? I mean, she was violating the custody order, but that's not enough. That's why it doesn't fit, ladies and gentlemen. By moving such person from one place to another, that's true, she did that, or by confining such person. We don't have the kind of confinement here that I would suggest rises to the level of a kidnapping. Restraint is without consent if it's accomplished by physical force. Did she restrain Gabriel by physical force? Did she restrain him by intimidation? Did she restrain Gabriel by deception? It sounds like craziness. It doesn't fit. Or by any means, including acquiescence of the victim if the victim is under 18 and the legal custodian doesn't agree. Well, clearly the legal custodian doesn't agree. But is this acquiescence of the victim? Is that really what we're getting at here with this statute? Or is this for somebody who comes up to a kid in a park who's 15 or something and says, hey kid, I got candy, come over here. And then the kid says, oh, candy, I love candy, let's go over here. That's what they're talking about when they say acquiescence of the victim and the legal custodian doesn't agree. It really doesn't fit. That's why I'm saying kidnapping just doesn't fit this case. Ordinary parental restraint is not kidnapping restraint. And that's why you have to look at the definition and go through it. If it was, then all parents are almost there to committing a kidnapping just by putting their kid in a car seat. If you just violate an order and then have the mental state, bam. So are parents committing elements of kidnapping by restraining their kids? That's why it doesn't fit. Don't fall for just because there's a custody order here, there's automatically restraint. I would suggest that just go to the elements and take a look at what restraint says. So, I've given you 3 independent reasons. The first 2, slam dunks. The imminent problem, no threat of an imminent physical injury to Gabriel, only a past injury, no other statements involving threat. Problem 2, Even if there are threats, it didn't happen at the time she's actually restraining Gabriel because she didn't have him after the 26th, and she wasn't violating anything before the 20th at 8 a.m. And even if she was, this isn't the kind of restraint that we expect to see in a kidnapping case. And the reason I'm saying that is because if you go through the elements of restraint in the definition, it just doesn't fit. That's why, ladies and gentlemen, we have jury trials. So you guys can look at this evidence as citizens and go through all of it. There are other important rights in our Constitution, like the right to an attorney, presumption of innocence. That's all part of our due process rights in our Constitution. And that's why in a criminal case, you got to have proof beyond a reasonable doubt. Beyond a reasonable doubt. You got to have no reasonable doubts. Whatever doubts you have to be unreasonable. They got to have that level of proof. And so to say that I'm wrong about everything I've said here today and conclude that, well, Elizabeth Johnson, she probably had an intent to place Logan in fear of an imminent physical injury. I think she probably did. You could still conclude that. That's a not guilty. Because probably doesn't get you there. Even if you say, well, she probably restrained Gabriel, I think that she probably did as per the legal definition of kidnapping. That's a not guilty. If you conclude that, well, she probably restrained Gabriel at the same time she had the intent, not guilty. All of those are insufficient. They got to prove each one of those things beyond a reasonable doubt. And there just is no support for that conclusion in this case. Now, she's not required to testify, and you have a jury instruction about that. She has every right to remain silent. The judge has already told you not to make a negative inference about that because she has a right to just sit there. But at the end of the day, ladies and gentlemen, given what I've just said to you, what on earth could she possibly add to the case by testifying? Like I said at the beginning, she could get up there and say, yeah, I disagree with this, I disagree with that, I disagree with the next thing. I really was a good mom. I loved Gabriel. I did all these things. I didn't do this. I just said this to hurt Logan. I didn't really kill him. I gave him to the couple in the park. She could say all that. But does that change anything about what the defense is here? No. Does it change anything about the state's lack of evidence on the kidnapping charge? No. So at the end of the day, there really isn't any purpose for Elizabeth Johnson to testify, because what I'm saying to you is even if you believe every single scrap of evidence that the state presented from day one up until the last day where they rested their case, if you believe every single scrap of evidence that they presented beyond a reasonable doubt, it doesn't change anything for what I've said here today. It just doesn't add up to kidnapping. Now, ladies and gentlemen, these rights that we have in our Constitution, there's a reason for that. There's a policy decision that underlies all of this. There's supposed to be a slant in favor of the defendant. That's why even the judge told you today, as she sits there, she's presumed innocent. We don't start even. Remember the judge at the beginning said, how would you vote if you could vote right now? Guilty, not guilty, or don't know? It's not guilty. There's a slant. It's supposed to be slanted in favor of the defendant. Why do we do that? We do that because there's a policy decision. Because we know, everybody knows that no system is perfect. There are going to be errors. We're going to get it wrong. Given that we're going to get it wrong in some cases, which way would we rather the error go? Are we more concerned about an innocent person getting convicted of something they didn't actually do? Or are we more concerned about a guilty person going free? Which bothers us more? Our country is more bothered by an innocent person getting convicted than 10 guilty going free. That's why there's a slant. That's why we start with a presumption of innocence. That's why you get a right to an attorney. That's why it's proof beyond a reasonable doubt. That's why you don't have to present any evidence in your case. You don't. It's not, imagine if the burden was reversed. You're guilty. What do you have to say? You didn't say anything? If you probably had that, you could reduce the amount of errors of innocent people, of guilty people going free. But what's the cost of that? That's why there's a slant. We have different standards of proof. They're in your jury instruction. I'm not going to belabor the point. Preponderance is what we normally go through our daily lives using, right? Who do we believe more? Who do we believe more? Somebody says, my kids get into a fight. I did this. No, I didn't. All right, get them both in here. What's the evidence? Who do we believe more? Most of the things, the decisions we make in life are by preponderance of the evidence. We call it 50 plus a feather. Who do we believe more? That's not the standard here. Clear and convincing, as the judge told you, is a higher standard. That's a big deal. If the government can show certain things by clear and convincing evidence, they can sever your parental rights. That's a big deal. That's a much higher standard. You have a definition of it. Beyond a reasonable doubt is the highest standard that we have anywhere in the justice system. That's the standard here. So, ladies and gentlemen, what does all this bring me back to? It brings me back, really, to the emotion issue, where I started. That's where it leaves me off. I think that what I've done here today is laid out for you at least two slam dunk, overwhelming reasons why this is not kidnapping. They're not sexy reasons. They're not emotional reasons. They're not the kinds of reasons that are going to fire you up. I'm not jumping up and down, pounding on the lectern because I'm so excited about their reasons. They're just simple reasons. They didn't prove their case. Those are the reasons. They just didn't prove their case as to kidnapping. So why is this still a hard case for me? Why am I still standing up here, spending so much time in closing? Because the challenge for me is to get you to focus on the elements. Because I know one thing. If I can just get you to focus on the elements of kidnapping, slam dunk, not guilty. The question is, can it be done? I think it can be done, and it has been done before. A hero of mine did it once. John Adams did this. Some of you may have heard of the Boston Massacre. I'm from Boston. I've been there. It's an interesting place. If you haven't been to the site of the Boston Massacre, you should go. But if you don't know about the Boston Massacre, I'll tell you very quickly. This is around the time of the Revolution. And it was around the time that John Adams' cousin, Sam Adams, was thinking about fermenting revolution. He was in this radical group called the Sons of Liberty. They're the guys that dressed up as the Indians and chucked the tea overboard so King George would know they were unhappy with his 2% tax on tea. This was a pretty radical group. They wanted revolution. And so the British soldiers are out there, and a lot of the townsmen in Boston approached them, started throwing snowballs at them, provoking a fight, started throwing other things at them. One of the British soldiers, who were very unpopular at the time, as you can imagine, fired his weapon, and what he says was self-defense. But Sam Adams seized on this as an opportunity and called it the Boston Massacre. Started cranking out all this propaganda to say, oh my God, the British soldiers just came through and they killed all these helpless townspeople in Boston. We got to drive the king and his British soldiers out of Boston. Now, I understand why he was doing this. He was doing this because he wanted to whoop them up into revolution. And he succeeded at that. They were whipped up into a revolution. And the British soldiers got charged with murder. And nobody wanted to stand up for them and defend them. They were as unpopular as you get. Sam Adams wasn't very happy when his cousin John Adams stood up and said, I'll defend all of them. And he did. He took some flack for it, I'm sure. Because he was standing up for a principle. He was standing up that before we take these people and lock them away on a murder charge, I'm going to be here to hold the standard high. Even though they were unpopular. This was a very unpopular act that one of my heroes, John Adams, as a lawyer, stood up and engaged himself in. But you know what? Maybe this is one of the reasons he was such a steadfast supporter of the jury system. Because he got the jury to look at the facts, and the facts were that the colonists the leader of the colonists did not give an order to fire into the crowd. Most of them were acquitted. The ones who were not acquitted were convicted of lesser crimes. Justice was done that day in an unpopular way. I respect a man like that. I respect the fact that he stood up and took an unpopular case and said, wait a second, let's just focus on the evidence. Let's not just sweep these guys away because we're upset with them. We're mad at them. It was a real validation of the jury system. What I'm asking you to do is to uphold the same principles. That's all. I'm not asking you to do anything other than just simply upholding the same principles that they started, that were so near and dear to our founders' hearts. And as I've said, the right decision is sometimes the hard decision. It may not be the popular decision. I think that it can be much easier to do the popular thing. And I think there's lots of that in our society. Before I close, I'm going to give you one other example that actually happened since this case started, since we got underway. It was something, before you guys came out on a few occasions, we were talking about out here. I was talking about with some of the people around the courthouse. It was a big story of the day, and some of you may know about it. If you follow football, you know there was a game between the Seattle Seahawks and the Green Bay Packers. It was a Sunday night football game, and it was being played in Seattle. And Seattle's fans were there, and that's a raucous crowd in Seattle. They are loud. That is known as one of the loudest stadiums in the National Football League. But what was different about this game was that the refs were on strike. What I would call the real refs, the professional refs, the Major League NFL refs were on strike. And what they had were the replacement refs who came up from the college ranks and probably were doing the best job they could. But the game was close, and as it came down to the end, the Seattle Seahawks were running out of time. They were down by a number of points. I don't remember how many. But what they wanted to do was a play that's pretty well known in football called the Hail Mary pass. It's the last play of the game. And the team that's losing drops back, and they send their receivers all the way down into the end zone, and the quarterback chucks it up there. There's a big pile of people in the end zone. And if Seattle catches it, comes down, it's a touchdown. Seattle wins the game. But if Green Bay catches it, it's an interception, and Green Bay wins the game. Or if Green Bay just bats it down, if it's not caught, Green Bay wins the game. We were all watching that game. It was a good game. And what happened was the Hail Mary pass went up. Some of you saw this, and I know that you know about this situation, because although you couldn't watch stories about Elizabeth Johnson, I know some of you saw this because it was all over the news. We saw it over and over and over again. What happened was, it was one of the Green Bay Packers, the defensive players, who went up there and caught the ball. Got two hands on the ball. He caught it. Everybody saw. It was an interception. Game over. But as he was coming down, one of the Seahawk players kind of got his hand on there, and the other hand, we couldn't quite see where it was. He maybe got a finger on or something, and he came down. Everybody who saw the play, with very few exceptions, thought that was an interception. But the replacement refs, they were in Seattle. And the crowd wouldn't have been too happy if the replacement refs found that this was an interception. So the replacement refs hustled over there and called that a touchdown. And the game was over. And the crowd went crazy in Seattle. The place went nuts. Seattle won this dramatic, last-minute Hail Mary pass. Fantastic ending, except for one thing. Everybody knew that under the rules, the Packers intercepted the ball, and the Packers should have won the game. And all the commentators who played this the next day, they said the Packers got ripped. The replacement refs, They kind of ignored the rules. They went with the easy call. The easy call was Seattle wins the game. They ran out of their heroes. The crowd couldn't have been more pleased with the replacement refs calling that Seattle won the game. But guess what? That was the last game ever for the replacement refs. That was the play that caused everybody else in the nation to say, you know what? We need to bring back the real refs. Because the real refs, they call it like it is. They don't get swayed just because they're standing in Seattle for the home team, knowing that there's going to be tens of thousands of people either loving them or hating them. They just make the right call, the call that the evidence requires them to make. And the replacement refs didn't do that. And they're gone. And they should be gone. What I'm asking you to do, ladies and gentlemen, is be the real refs. Be the big league refs. This is a big league game here. You're in Superior Court. They're felony charges. It's a criminal case. Be the big league refs. Don't you want to say, for the rest of your life, when you were on the jury, you made the principled call? Whether it was popular or not, whether you wanted to make the other call or not, whether you liked Elizabeth Johnson or not. You looked at the evidence, you looked at the elements, and you made the call that was a principled call, the call that you were required to make without regard for whether it's going to be popular or unpopular, without regard for whether it's the easy decision or the hard decision, without regard for any of that. That's all I'm asking you to do, ladies and gentlemen. From the first day you were here, all I tried to get you to do was to focus clearly on the elements. And I think I've done that. I've taken you through those elements as clearly as I could. I think if you focus on the elements, it's a slam dunk. What I'm asking you to do is to look at that and come back with a verdict of not guilty on kidnapping. Thank you for your attention.
Thank you, Mr. Victor. Now the state gets an opportunity to rebuttal. I think, Ms. Ramuno, are you going to present the rebuttal?
Yes, Your Honor.
You may proceed.